Chris, can you please tell us what obstacles you've encountered in filing civil suits against the police for civil rights violations, and how often do those cases even make it to juries?
Chidi, thank you so much, and it's a pleasure and an honor to be here with the other speakers. The challenges with these cases, they're primarily twofold. The first challenge is the doctrine of qualified immunity. It is an onerous doctrine and provides immunity to officials who do all but the most blatant and egregious acts. When you consider the costs of these cases, they require expert witnesses, and the manner in which they are defended and fought by the defendants, you have to consider whether or not it's going to be worth it. The second hurdle is how damages are calculated. And as you touched on in that very kind opening, most of the victims of police brutality and excessive force are low-income minority persons. And when you're calculating damages based on those persons' income and how to the extent their dependents relied upon them, it can become very difficult. Getting to trial can be challenging, and those challenges that which everyone's aware of can result in settlements that can be a little surprising. You know, if you Google wrongful death settlements, excessive force settlements, you'll see them ranging anywhere from $300,000, $900,000, 1.2 million, 800,000. You'll see some 2 million, and then you'll see some outliers. And that's mainly because the time and effort of expense of taking a case like this to trial, the risk of surviving on motion for summary judgment, raising qualified immunity, can result in a family expressing a desire to accept a figure that might be shocking for the loss of someone's life. In my case in particular, the one you discussed, Jones versus the estate of Martinsburg, that's in Martinsburg, West Virginia, Northern District of West Virginia. And they had a particular problem in that case. Prior counsel that handled the initial litigation before the district court failed to respond to requests for admissions timely. And those admissions were that Mr. Jones had a knife, that Mr. Jones attempted to stab an officer, that Mr. Jones refused commands to drop the knife. And as one can imagine, those admissions were problematic, resulted in the first grant of summary judgment. And it's at that point that I entered the case on that first appeal. When you have facts like that, and their admissions, and you're going up against the doctrine of qualified immunity, it can be an extremely difficult hurdle. And qualified immunity essentially protects officers if they can express any inkling that they were in fear for their own safety or the safety of others. And the fact pattern must have been, to some extent, previously reviewed by the court, because it's a notice doctrine, really, to a government actor that if you engage in this particular behavior, then you may be liable. Having a knife, attempting to stab an officer, and refusing commands to drop the knife were an easy out for the judge to grant summary judgment in the first case. The best way to approach this is try to take it out of that paradigm where the officers can so easily say they had some fear for their safety or the safety of others.
Chris, with that admission that he attempted to stab an officer, how did you win that appeal? I mean, that sounds like a slam dunk.
On its face, I think that's why they had some difficulty finding counsel. Their counsel withdrew after summary judgment was granted. But I reviewed the case, and I came up with a pretty creative approach. And as I argued to the Fourth Circuit, there is clear case law that once a subject is subdued, excessive force may not be employed. And I made the argument that there were 5 officers on top of this 50-year-old, 162-pound man who'd been tased 3 times, beaten and held in a chokehold for 17 seconds. At that point, he was subdued. He was no threat. And for the officers to back away and release him from being subdued point their guns at him and yell at him for 6 seconds to drop the knife when he appears to be unconscious in the video. I held that we had to restart the Graham factor test. So there's a set of factors you look at to determine whether or not excessive force is reasonable. Was the victim resisting arrest? What was the nature of the crime he was suspected of having committed? What factors led to the officers being in fear for their safety? And I approached it from that angle so that I could reframe the argument and take it away from this very difficult view under qualified immunity and approach it from sort of this restarting of the clock from the point he had 5 trained officers on top of him. And, you know, if you read the oral argument transcript, the comments of Judge Gregory were fantastic. I mean, I quoted Judge Gregory extensively in my brief in the subsequent appeals. As we got remanded, it got dismissed again. And the reason that occurs, it may be a little confusing. How does the judge dismiss the case 3 times? Is every time we got remanded, she would say, well, I didn't reach this issue. So you have this test that occurs, and she dismisses on the first prong of the test. It gets remanded. She goes to the second prong of the test and dismisses it. And then on the second remand, she drops down to qualified immunity and says, well, I didn't reach that issue. Now I'm going to dismiss it on qualified immunity. And there was concern on our end. You know, there was a Rule 68 offer of judgment of $1 million.
Wow.
After during the second remand. And that's a close call.
Can you tell everyone what an offer of judgment is? I've had one in a case. I had to look it up to figure out what it was, but I don't spend a lot of time in federal court. So there may be people here who aren't familiar with it.
It is a powerful tool that may only be employed by defendants that allows the defendant to say, I'm going to make you this offer. It's going to be filed with the court online, public. And if you don't accept it and you get less than we've offered you, you will have to pay us our attorney's fees from this point forward that are incurred. It is a troubling tool that plaintiffs may not employ. So it was an incredibly wise strategic decision to make for them to do that. But nonetheless, we held strong and did not accept it and pushed forward.
And who was your client? I know it was his estate, but I imagine that conversation with the client might have been pretty difficult. I mean, after having the case dismissed, going up on appeal, and then coming back, and then telling a client, yes, they've offered $1 million, and don't take it. That must have been a difficult conversation.
Not as difficult as you would think. Yes, that was not it was not an unreasonable offer given the facts of this case. I'll concede that. But I'll tell you from day one, my clients had no interest to their credit in money. While you pointed out that this result, the $3.5 million settlement, is good for a plaintiff with no income and no dependents, my clients are more concerned with these officers losing their jobs, losing their pensions, being prosecuted, and they were less concerned about money. So I'll be honest, I was the one saying, this is a reasonable offer. And they were the ones saying, we are not interested, which turned out to be the right call.